from the California Department of Tax and Fee Administration's Business Taxes Committee team. Today's hearing is being held to receive public comments regarding the department's proposal to adopt Public Records Act regulations 35301 to 35305. I will give a brief summary of each regulation and then open the hearing for comments. Proposed Regulation 35301, Purpose and Scope, explains that access to public records maintained by the department is governed by the California Public Records Act. It further explains that the purpose of the new regulation is to facilitate public access to the department's public records and provide a better understanding of the types of public records available relating to the department's tax and fee programs. Proposed Regulation 35302, Disclosure Policy, sets forth the department's policy to provide access to records that are not exempt from disclosure by state or federal law and permit the inspection and copying of any reasonably separated portion of a public record after deletion of portions that are exempt from disclosure. The regulation also provides a non-exhaustive list of examples of records that the department deems exempt from public disclosure, including tax and fee information that must be kept confidential under state or federal laws, confidential legal advice, records prepared in connection with litigation, preliminary drafts of interagency memorandums or other documents not retained by the department staff in the normal course of business, personnel, medical, or similar files, and test questions, scoring keys, and other data regarding licensing, employment, and academic examinations. Proposed Regulation 35303, Cost for Copies of Public Records, provides that the department's general policy is to require any person making a request for copies of public records to reimburse the department for the cost of duplication. The copying fee may be waived if the cost for records is less than $10. The regulation also provides that if a department must compile or extract electronic data or perform computer programming to produce a copy of an electronic record, it may charge its full costs. Proposed Regulation 35304, Procedure for Requesting Public Records, describes how to request to inspect or obtain copies of the department's public records through our disclosure office. The regulation requires requests provide a sufficiently specific description to allow the department to identify the requested records and explains that the disclosure office will assist the public in making focused and effective requests that reasonably describe identifiable records. And finally, Proposed Regulation 35305, Public Records Available, specifically identifies and describes the types of public records pertaining to the tax and fee programs administered by the department. The regulation identifies the public records that are available on the department's website and the public records that can be requested through the disclosure office. Before we open the hearing for comments, I want to remind you that whether or not you make any more oral remarks today, you are welcome to submit written comments by sending them to the email address cdtfaregulations@cdtfa.ca.gov. All written and oral comments provided today will be taken into consideration and addressed in our future rulemaking documents. We have one speaker scheduled, Mr. Jesse McClellan from McClellan Davis. Mr. McClellan, you can turn on your camera and unmute yourself.
Okay, thank you. Can you hear and see me?
Yes.
Great. Well, number one, I appreciate the opportunity to speak. I certainly appreciate you guys allowing me to speak first and last. I've just got a couple of comments. There's, I've been making California Public Records Act requests for quite a while, for the most part without incident. And I think the agency historically has done a good job getting those to us, and I appreciate that. I appreciate the nature of this regulation. While there is not a lot of participation, obviously, I consider it to be a very important fundamental law, and therefore the regulation by extension is also very important. I had some questions. I've talked with some of you guys about the fees and so forth. It doesn't sound like electronic records of the type that at least our firm typically requests. We'll incur a fee. Usually if we have a client that retains us for one reason or another, we request their file. And it sounds like that's going to be business as usual. The other item, and I've got 4 items, this will go fairly quickly, I believe. The other item that we have issues with sometimes, and I think it would help to have clarification in the regulation. I don't know if staff is still open to adding some things to the regulation, but it pertains to audit working papers. So as many of you know, a lot of what my firm does is manage audits or defend audits. So of course the audit working papers are an important aspect to that. And so we request them, usually just ask them to be emailed, which they most generally are. Every once in a while there's some reluctance to do that, I think just because the person at the other end doesn't know that they can or that they're supposed to. And so what ends up happening is they'll put them in a PDF form and send them that way. They're much more efficient to review and address in an Excel format. And ultimately, these things are always worked out. And sometimes it can take some time, not significant, but I think it would be a nice clarification to have. And for your reference, Section 6253.9, subdivision A1 of the California Public Records Act requires disclosure in the form that they are made, used, and maintained. And I don't think there's any dispute about that. That would be a good clarification, in my opinion. The other thing that comes up on occasion are emails. So oftentimes we get copies of emails related to a case, whether it be between an auditor and the supervisor, or the auditor and the reviewer, or communications between BTFD and appeals. They're sent, not an issue. Sometimes they're not. And again, it seems to be depending on who we're working with as to whether or not they're sent. And they're obviously, the California Public Records Act specifies that written records should be provided to the public. And I don't think there's any dispute that they are subject to disclosure. We typically get them, but there seems to be some confusion in that regard. Again, clarification on that front, I think, would be worthwhile. It would save time, both on the public's part and on staff's part. The last point, which I think is important, it doesn't come up much, but the publication that Lynn was kind enough to send over does address situations where you don't get the records that you're asking for. And generally speaking, we're familiar with who to chat with and how to resolve those things. Most people wouldn't be, I think. But the law does say that the names and titles or positions of each person responsible for the denial should be provided in the written response. And that's code 6253D. And I may be citing that incorrectly. And I will be making a short written submission after this. But bear with me, I'm sorry. 6250, yes, it is. 6253D is the subdivision that requires that. I think that would be something that's good for the public to know. That way they know who to call and say, look, why am I not getting this? Can you explain? And gives a point of contact other than, hey, look, the agency just is not allowing it. And I think there's a good public purpose behind that, in that it it prevents scenarios where there's just sort of a wall put up and saying, well, we're not disclosing this as an agency. And if you can specify the person, that often helps to resolve any issue. Other than that, again, I thank you for the opportunity to make these comments. I thank you as an agency for taking this on a proactive basis. And I don't have anything further to add. If there's some questions that I can answer now, I'd be more than happy to do that. If there's questions that I can answer later, I'd be more than happy to do that as well. Thank you.
All right, thank you, Jesse. We do not have any other speakers scheduled for today, so this will conclude today's public hearing. As mentioned, if you may submit written comments today by sending them to the email address cdtfa regulations@cdtfa.ca.gov. This concludes today's public hearing. We thank you for your participation.